If you have Haiti TPS, or you employ someone who does, today is the last confirmed day your work permit is valid, and no one knows for certain what happens tomorrow. Under the latest guidance, certain Haiti TPS work permits remain valid through July 27, 2026. But this is a short, court-ordered extension, not a new renewal, and there's no guarantee another one is coming. In this video, I'm breaking down exactly which cards are still covered, what employers need to check before turning anyone away, and the steps you need to take right now before this deadline passes. As of July 27, 2026, the latest USCIS guidance tells employers to treat covered Haiti TPS employment authorization documents as valid through today. An employment authorization document is often called an EAD, or work permit. It is used to show that a person has permission to work in the United States. The July 27th date comes from the court process that followed a major Supreme Court decision. There is no verified broad extension beyond July 27th in the latest information available at the time of this recording. Another order, or USCIS update, could still change the answer. Because this is a same-day deadline, check the official USCIS Haiti TPS page and the latest Form I-9 guidance before relying on this video after today. To understand why the date moved, we need the legal path in simple words. Temporary Protected Status, known as TPS, is temporary help for eligible people from a country facing war, disaster, or other serious danger. Valid TPS may provide work permission and protection from removal. It does not itself give a green card, citizenship, or permanent status. Haiti first received TPS after the major earthquake in 2010. The designation was later extended and changed several times. In November 2025, the Department of Homeland Security published a notice saying that the Haiti TPS designation would end on February 3, 2026. A federal district court then delayed that termination while the case continued. This kept TPS and related work permission in place for covered Haitian beneficiaries. The major legal change came on June 25, 2026. The Supreme Court decided related Haiti TPS cases. The court ruled that the TPS law blocks courts from reviewing the main claims about the process used to end a country designation. The court also said the Haitian plaintiffs were unlikely to win the equal protection claim that was before it. The Supreme Court reversed the lower court relief and sent both cases back for further steps. There is an important difference you need to understand. The Supreme Court did not personally cancel every work permit on June 25th. It decided the legal questions before it and returned the cases to the lower courts. The lower courts then had to complete the next steps. USCIS also had to update employer guidance, Form I-9 instructions, and expiration dates. During that process, several short dates were used. The latest confirmed date for covered Haiti TPS work permits is July 27th. Before the Supreme Court decision, lower court orders delayed the Haiti termination. After the decision, the courts still had to complete the next steps. Covered workers remain authorized through July 27th under the latest USCIS guidance. A later court order or agency notice could still change what happens next. Now let us look at the documents directly covered. The current guidance applies to certain Haiti TPS work permits with category A12 or C19. These codes are printed on the card. Category A12 is commonly used for a person who has been granted TPS. Category C19 is commonly used for a person with a pending first TPS application who received temporary work permission. But the original expiration date on the card also matters. The covered dates include February 3, 2026, August 3, 2025, August 3, 2024, June 30, 2024, February 3, 2023, December 31, 2022, October 4, 2021, January 4, 2021, January 2, 2020, July 22, 2019, January 22, 2018, and July 22, 2017. A card may show an old date and still be valid through July 27th, when both the category and the original date match the current guidance. This is the first point many workers and employers may miss. The date printed on the front of a card does not always give the full answer. A court order or government notice can extend the use of a card without USCIS printing a new one. An employer should not reject a covered document only because the printed date looks old. Imagine a worker named Marie. This is only an example. Marie has a Haiti TPS work permit with category A12 and an original expiration date of February 3, 2026. Her manager sees that date and tells her she cannot work on July 27th. Marie calmly shows the latest USCIS guidance, stating that her covered card remains valid through July 27th. The employer reviews the Form I-9 instructions and corrects the record. In this example, the old printed date did not mean Marie lacked permission to work today. For Form I-9 purposes, the latest guidance tells a covered worker to enter the words, "as per court order," in the Section 1 expiration field. It tells the employer to use July 27, 2026 in Section 2 and add the required note in the extra information area. Form I-9 is the federal form used to check identity and work permission. Employers should follow the latest official instructions instead of making their own rule based on nationality or the age of a card. But the next point is more serious. Valid through July 27th. Does not promise that the same card will remain valid on July 28th. If no new court order or USCIS notice appears, a person whose only work permission comes from Haiti TPS should not assume that work can continue after today. The employer may need to check work permission again before allowing the person to keep working. This new check is called re-verification. It means the employer must confirm that the worker still has valid permission to work. During this process, the worker may choose any acceptable document allowed by Form I-9 rules. The employer should not demand one exact document, such as a new TPS card, when another acceptable document is available. Not every Haitian national depends on the same legal basis. One person may have only a TPS card. Another may have a work permit based on a pending green card case or asylum case. Someone else may already have a green card or another status that allows work. The end of a TPS card does not automatically cancel a separate work document that remains valid. Check the category and date on the document you use. Now return to Marie for a second example. Marie believes that a family petition filed for her means she can automatically keep working after July 27th. That may be wrong. A family petition can be an important first step toward a green card, but it does not always provide immediate lawful status or work permission. Marie needs a full review of her entry history, current forms, visa availability, and any other document that may allow her to stay or work. The next major issue is protection from removal. Valid TPS normally protects a covered person from removal under that program. If Haiti TPS ends, that TPS-based protection may also end. However, this does not mean every Haiti TPS holder will be arrested or removed on July 28th. There is no single automatic event that happens to every affected person at the same moment. Your own immigration record matters. You may have another valid status, a pending asylum case, a pending request for another form of protection, an immigration court case, or an old removal order. Each fact can change the answer. A person with a final removal order may face a different level of risk from a person who has valid status through another program. A pending case may help in some situations, but filing an application does not always create status or protection by itself. Years in the United States, tax payments, a job, a home, or United States citizen children do not automatically create lawful status. Those facts may still matter in a full review, but they do not replace a valid category. Some people may have another family, work, humanitarian, or court-based path depending on their history. Before I walk you through exactly what you should do today to protect yourself, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. The biggest hidden risk is waiting for another extension without preparing. The deadline has moved in short steps since the Supreme Court decision. This may lead some people to believe another extension will always arrive. No official source has promised that. Waiting until an employer stops work or until a government notice arrives may leave less time to review lawful choices. Start with a full record check. Find every work permit you have received. Keep copies of your TPS forms, notices, passport pages, and arrival record, often called an I-94. Also collect asylum papers, family or work petitions, court records, and travel documents. If you received a notice to appear, do not ignore it. This document can begin a case in immigration court. Tell your lawyer about any missed hearing, removal order, arrest, other name, fraud issue, or facts that do not match across forms. Hiding a hard fact can lead to bad advice. Travel needs special care as well. Do not leave the United States only because an old travel document appears unexpired. The end of TPS, time spent without status, an old removal order, or the way you entered, may affect your ability to leave and return. Before booking travel, confirm that the document is still valid and ask how leaving may affect every pending case. Employers should prepare too. Review the latest USCIS Haiti TPS alert, the category on the card, and the listed original expiration dates. Do not remove a worker early only because the front of a covered card shows an old date. At the same time, do not assume work permission continues without an end date forever. Keep checking the official guidance and be ready to complete re-verification if no new extension appears. Federal law also protects workers from unfair document demands. Employers must apply Form I-9 rules in the same way for all workers. They should not ask for more or different documents because a worker is Haitian, has TPS, or speaks with an accent. During re-verification, the worker may choose from the acceptable documents allowed by law. A worker who believes an employer is rejecting a valid extension or demanding one exact document may contact the Department of Justice Worker Hotline at 1-800-255-7688. There is another part of this story that has caused confusion. A separate court order last week blocked parts of a different work permit policy for certain TPS holders and asylum applicants. That separate order does not automatically extend Haiti TPS. The Haiti deadline comes from different litigation and different USCIS guidance. Do not combine two court cases and assume one order protects every group. Let us correct 3 common rumors. Some posts say every Haiti TPS holder lost work permission before July 27th because the date printed on the card had passed. That is false for a covered A12 or C19 card with one of the listed original expiration dates. The latest guidance treats those covered cards as valid through July 27th. Other posts say every Haiti TPS holder can keep working after July 27th because a judge protected work permits last week. That is also false. The separate case does not automatically decide the Haiti deadline unless new Haiti guidance appears. Do not assume that TPS-based work permission continues after today. A third rumor says everyone will be removed as soon as the deadline passes. That is misleading. Ending TPS may remove an important protection and may increase risk for a person with no other status or protection. But court history, pending cases, other valid status, and personal facts all matter. The deadline is serious, but it does not create one automatic result for every person. So, what should you do today? First, check the category and original expiration date on your card against the current USCIS guidance. Save a copy of the latest alert and the Haiti TPS page. Keep those records with your card and your Form I-797 notices. If your employer is confused, calmly ask the Human Resources team to review the current Form I-9 instructions. Find out whether TPS is your only basis for work and protection from removal. Do not describe every document only as "my work permit." Write down the category, printed date, receipt number, and the application connected to each document. This can help a lawyer or accredited representative understand your case faster. Then seek a complete immigration review as soon as you can. Use a licensed immigration lawyer or a Department of Justice accredited representative. Be careful with notarios, unlicensed advisors, and anyone who promises a green card. No honest person can promise an approval without reviewing the facts. No one can promise what a future court or agency decision will say. Do not file a random asylum case, family form, or work permit request only because someone online says it will save TPS holders. Do not send false information, hide an arrest, invent a job, or create a fake relationship. A false or weak filing can harm future options. Do not make a major travel choice based only on one video. Do not miss an official deadline while waiting for another announcement. Covered workers have a clear answer through July 27th under the latest guidance. Do not leave work early or accept an incorrect Form I-9 decision based only on an old printed date. Use today to organize records. Speak with your employer and seek trusted help. This extension is still very short. If no new order appears, people who depend only on Haiti TPS may lose TPS-based work permission and removal protection. Preparation cannot promise a result, but it can help you avoid mistakes and respond faster. We will keep watching for any court order or USCIS notice that changes the July 27th date. Because an update may appear after this recording, check official information again before working on July 28th or making a major immigration choice. Immigration rules can change quickly. This video reflects the information available as of July 27th, 2026. It gives general information and is not personal legal advice. Every case has different facts. Anyone facing a work deadline, removal order, court hearing, arrest, travel plan, or complex filing history should speak with a qualified immigration lawyer or accredited representative. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.